Item brought with kind permission. Sorry, my lord. This money bill is the next 7-judge matter. Will it be taken up Tuesday now, my lord? Because
I have given the order. If I'm not mistaken, Chinaya is going to be taken up.
that is that.
Perhaps that has been
splitting.
notified already. We'll start with
So
Chinaya.
money bill will come after that.
So that I think he has already notified the order, if I'm not mistaken. Today, he said court martial
Because
today.
originally this was supposed to come on 30th.
Oh, yes.
So then we plan that next week it will not be there.
But 9 judges will not be listed.
Sorry?
9 judges matters will not be.
9 judges immediately after that.
So
After this matter, I'm sorry, we'll see the notification.
After this, we will do Chinaya.
after Chinaya money bill.
And after Chinaya, possibly money bill, and then we'll take the 9 judge matters. Because
Mines and
those
minerals.
two are pending for 25 years.
Yes, mines and minerals.
Mines and minerals and the Maharashtra,
Industrial alcohol.
that property
Synthetics and
owners
chemicals.
association.
No,
Yes, Maharashtra for property.
No,
Pending for
for Maharashtra is that synthetics and chemicals. Lordship has referred that.
That, yes. That
That
also
will be
will
after
be taken.
Maharashtra.
Let me see how.
Lord, instead of asking your lordship, we'll see the notification.
Yeah, because it depends on, if you want a little break in between two matters or whatever. So
Lord,
what other pile up is,
Lord, yes.
because anytime, that's the one thing you are constantly juggling, the regular board and the constitution bench. Because we also have, you're right, because that's industrial alcohol.
Yes.
That arises from Justice Sabyasachi Mukherjee's judgment.
No, just Altamas Kabir's judgment as referring that whether it should be reconsidered.
The earlier one. Synthetics is Justice Sabyasachi Mukherjee.
No, yes, Jeevan Reddy also. Yes. Deeply obliged.
Grateful to.
That particularly, I think, all over the country, there are huge ramifications for the states as well as to who
Yes.
can
Several
collect
matters
revenue.
which are
Because
awaiting.
now that's the only source of revenue more after GST,
Right.
diesel and
Yes. Yes, that's one.
Lord, I want to go into the question of administer. But before that, just because there were so many random arguments, I just want to flag one small argument, my Lord, that they said that the 20 Act was standalone. Just, my Lord, every single statute dealing with minority is standalone. Nothing, my Lord, emanates from that. My Lord, on administration, I want to first address your lordships on 4 phases, my Lord, that take place as far as the statutes are concerned. The first phase, my Lord, is 1920 to 1951. Given the position of the court, my Lord, it clearly establishes the minority character. And I'll take your lordships, my Lord, to the relevant provisions. The second, my Lord, is from 1951 to 1965. And to be read with Aziz Pasha. Small changes were made in 51. And my Lord, the 65 Act, it was made from Supreme to Advisory. Now, my Lord, our respectful submission is
Then the
that,
third phase.
sorry, my Lord.
That's the second phase.
The third phase, my Lord, is from 65 to 81. But on the second phase, my Lord, since Aziz Pasha confined itself to the fact that the statute dropped it from a minority character, my Lord, had that not been done, that very narrow argument in Aziz Pasha, the provisions would have been struck down. But it was preempted, my Lord, because they did not examine the 51 Act. What Aziz Pasha, in fact, said was it was brought in conformity to the Constitution. That's as far as 51 is concerned. And 65, my Lord, that important part of Mr. Chagla's narration, my Lord, it was an emergency measure. And they did not go into the details because they had decided on the narrower point that because it was a statute. And then, my lord, 81, from 81 onwards, my lord, even if you discount the changes that were struck down, full supreme body and the corrections were completely made in conformity with 1920 to 51. So, my lord, I'll take your lordships, my lord, straight away to certain provisions of the statute as it stood in 1920.
So really speaking, you're talking about 4 phases.
Yes, 4 phases. And therefore, what were we doing? We were always petitioning the government. But these 4 phases, the only controversial phase is 51, my lord, to 65, and of course, Aziz Bhasha. That's the only controversial one. Sorry? 65 to 81, sorry. That's the 3rd phase.
So let's.
Now, if you look at it overall in the phases, my lord, what happens? The minority character was robbed to some extent, my lord, by 51 to 65. 51 specifically, my lord, says that it is to bring the statute in conformity, 51 in conformity with the constitution. And this is a finding, my lord, in Aziz Bhasha. And 65 was an emergency measure. And the emergency measure, my lord, is recognized also not just by the speech of the minister, Mr. Chagla, but it's also recognized in the SOR, that's the Statement of Objects and Reasons, in the 72 Act. Otherwise, my lord, throughout this period, it was, apart from this exception, throughout this period, my lord, it is the minority character that existed, but for these 2 particular statutes and but for the judgment in Aziz Bhasha.
Let's quickly run through the statutes. I think
I will, my lord. I'll
something
do
which
it as,
yes.
I think the operative word is quickly. Now, my lord, do we want to strike rector? Now, my lord, your lordships will find that there was a distinction made between officers in section 16.
We go to volume 4A.
Volume 2G, 3G. These were officers, what were the others? And my lord, in section 22, authorities. I'll just take your lordships, my lord, straight away to them. Give me the 20 Act.
Volume 3G.
$65. That's right. That's right. $16. Became Lord Rector. May I invite your lordship's attention, my lord, to PDF 9. I had made a distinction earlier when I opened, my lord, between the overall supervisory functions and the actual administration. So, my lord, 13 I'll just read. The Lord Rector, later becomes the visitor, shall have the right to cause the inspection to be made and then an inquiry. These are supervisory functions which go to, my lord, any external authority. Then, my lord, I take your lordships to 16. This is the officers of the university, which are the Chancellor, Pro-Chancellor, Vice-Chancellor, and Pro-Vice-Chancellor. But kindly come, my lord, to PDF 10, Section 17. After the succession period, my lord, is over, it is the Chancellor shall be elected by the court. This is the significance of the court, which I will elaborate on. Section 18, the Pro-Chancellor shall be elected by the court. Item 9, Section 19, the Vice-Chancellor shall be elected by the court from its own members, who are all Muslims. And 20, my lord, the Pro-Vice-Chancellor shall be appointed by the court. So as far as the officers of the university are concerned, it is the court that either elects or, my lord, appoints. And this central part is the court that is the nerve center, which I'll come to in a moment. Now, my lord, come to 22. The authorities, my lord, are in 22, the court, the executive council, academic council, and such other authorities. We find as far as the authorities are concerned, the Lord Rector, the Governor General are not part of the authorities. That is, now, my lord, 23 has been read, but I'll quickly go through it. The court shall consist of the Chancellor, Pro-Chancellor, and the Vice-Chancellor for the time being, and such persons as may be specified. The proviso, my lord, is important. That is in the first phase. Provided that no person other than a Muslim shall be a member. 23(2), the court shall be the supreme governing body of the university and shall exercise all the powers of the university not otherwise provided by the Act, statutes, and ordinances. It shall have the power to review.
Mr. Dawat, just one thing. The proviso, when it says no person other than the Muslim shall be a member thereof, is only restricting itself to the members, not to the others.
That's right, my lord. That's the point, my lord. As far as the composition is concerned.
Composition is concerned, because whether members will include the Chancellor, Vice Chancellor, not strictly, because members will be,
No, they're all members.
they are all members. And
Lord,
such
because
other
they become
persons
members of the
specified-
court, they have to be Muslims, my lord. Because members of the court will only
what-
be Muslim.
so
So
what
these
the-
persons will, by their very nature, have to be Muslims.
So what you are saying is the proviso makes it mandatory that everyone, right from the Chancellor to the Vice Chancellor and other persons, will be Muslims.
Yes, my lord. Yes, absolutely. And that is how it works out, my lord, in the first phase and post 1981. Now, my lord, 3 has not been read out properly, my lord. But 2, I was pointed to have the power to review the acts of the executive and academic councils. So there is a reviewing part, my lord, in the court. Then, my lord, direct that necessary action be taken by the executive or the academic council, as the case may be, on recommendations by the Lord Rector. So the Lord Rector, my lord, is somebody who makes recommendations, and they will be considered by whom? The court. Now, 3 is very important, which has not been read out to your lordships. Subject to the provisions of this act, the court shall exercise the following powers and perform the following duties, namely, of making the statutes or amending and repealing the same. This is a very important power as far as the statutes are concerned. The next, of considering ordinances. Number C, of considering and passing resolutions on the annual report and annual accounts. That's the financial power, my lord, to consider. Of electing such persons to serve on the authorities of the university, and of appointing such officers as may be prescribed by this act and statutes. Of exercising such powers and performing such other duties as may be conferred or imposed by the Act and other statutes. Now, this is an extremely wide-ranging power in the court. And this, my lord, 23(3) is operative throughout, my lord, the period, even in phase 2. '81, my lord, there's some dilution, and then, my lord, it's restored in '81. Now, my lord, the Executive Council, my lord, shall be the executive body of the university. Then 5, my lord, the Academic Council shall be the academic, and that, my lord, is not relevant to the court part. Let me take your lordships, my lord. In 28, where the first statutes, my lord, may be amended, that's subclause 2, may be amended, repealed, or added to by the statutes made by the court in the following manner. So here, once again, my lord, the court has a very significant function. That is in 28, subclause 2. And then the following manner is, the executive may propose to the court the draft of any statute to be passed by the court. So the draft comes to them and they decide whether it should be passed by the court. Such draft shall be considered by the court at its next meeting. The court may approve such draft and pass the statute, or it may reject it or return to it to the Executive Council for consideration, either in whole or in part, together with any amendments which the court may suggest. So here is an extremely significant power in the court. The nerve center, my lord, in the first stage and the third stage, 81, is quite clearly, my lord, the court and nobody else. Huge power, my lord, as far as statutes are concerned, huge power as far as ordinances are concerned. Then, my lord, if I may take you. Now, the proviso here, my lord, in section 28, that's PDF 12, provided that no statute dealing with instruction of Muslim students in the Muslim religion and theology shall require to be submitted or approved. That is an exception that is made out in the proviso. Then, my lord, if I may take.
But the only point
Sorry?
they had emphasized was C says that no statute, no new statute or amendment or repeal shall have any validity unless it has been submitted through the visiting board to the Governor General in Council.
Yes,
Now, significantly, this clause C does not refer to the rector.
that's
It
right.
refers to the Governor General in Council.
It
So
refers
really
to
the rector was to be the Governor General.
Not in any case what we are.
So it brings in an outside body, namely the Governor General, who has the power to approve. I mean, it's a prior approval of the Governor General.
Yes, ma'am.
So-
But then it comes to the court, and the court is the deciding
So
body.
therefore, the Governor General in that sense was not just a supervisory power in this particular provision. The Governor General had an overriding power to virtually approve any amendment, repeal, whether there should be a repeal of a statute, so on and so
But
forth.
not to initiate. Eventually, that is there, my lord. And as I had indicated earlier, my lord, these particular are supervisory functions, and in this case, as your lord points, my lord points out, a decision-making function as well. The proviso, my lord, your lordships, which I pointed out, is an extension of 28 2C, provided that no statute dealing with the instruction of Muslim students in the Muslim religion and theology shall be required to submitted or approving. So this is a huge exception that is, my lord, there in the proviso. So the Lord Rector, my lord, has no, my lord, function as far as Muslim teaching is concerned. Now, my lord. Going to forget.
The first statutes are by the Governor General in Council and no amendment can be made without him.
No, it has to be.
Yes. No, without. He is the complete source of statute and ordinance.
Now, my lords.
And actually, this act was made, my lord, under the 1909 Council, not 1919 Act. Because the 1919 Act came into force on 9th February 1921 after the first elections. So the Council Act was continuing, my lord, and the council was nothing but the officials and a few nominated members.
So who enacted this act then?
Governor General in Council under the Act of 1909.
Oh, 1909.
Indian Council Act 1909. So though the Government of India Act is of 1919, it came into force after elections on 9th of February 1921.
In fact, it says that passed by the Indian Legislative Council and received the assent of the GG on 14th of September 1920.
The council was earlier also there, but this diarchical system came later.
By the 1919 Act.
And therefore, by rules, not both these institutions, BHU, and they were kept with the Governor General in Council. And rest were transferred, education was transferred to the provinces by rules.
My lord, we are not denying that in the imperial statute, my lord, this overriding power with the Governor General existed, as your lordship said. We're not denying that, but it doesn't take away, as we'll explain further, my lord, it doesn't take away from the power of the court as a proposing body or otherwise. So the initiation, my lord, in effect comes from the court. Now, my lords, I come, my lord, now to, no, I don't. My lord, kindly come to the statutes on PDF 16.
Just see page section 30, ordinance, or the section 30, or the power to make ordinances.
Which section was your lordship?
Section 30.
30. The Executive Council, my lord, I've marked it, or in academic matters, the Academic Council may make ordinances. I'll tie this up, my lord, when I read the statute.
And then 30, clause 3.
No new ordinances or amendment or repeal of any existing ordinance shall have validity until it has been submitted through the court and the visiting board, which may record its opinion to the Governor General and has obtained the approval of the latter. So, my lord, here is an important aspect that comes through the court.
And 30, clause 2 says the first ordinances will be as framed by the Governor General.
Yes.
And no new then can be made without it.
That was an interim measure, my lord, the first ordinances. We're now looking at the change and who had the power. The power, my lord, here is through the court and the visiting board. Now, the visiting board, as I'll show to your lordships, my lord, that provision has been deleted later on. Now, my lords, 31. The authorities of the university may make regulations. And who are the authorities, my lord? The authorities, my lord, that have been mentioned at PDF 11, my lord, in section 22, which I've already read out to you. And the authorities here are the Chancellor, Pro-Chancellor, VC, Pro-VC. The court, yes, of course. I've already indicated that they'll be appointed and elected. I've already indicated that. My lord, I don't want to go into it further. Then, my lord, 31.1, my lord, on PDF 14. The authorities of the university, and I've indicated who they are, may make regulations consistent with the Act, statutes, and ordinances. Governor General, my lord, doesn't come under the authorities of the Act. And then 31, my lord, clause B in 1, providing for all matters which by this act, statutes or ordinances shall be prescribed by the regulations. Then, my lord, every authority of the university shall make regulations providing for the giving of notice to the members of such authority, dates of meetings, and of the business to be conducted, or keeping a record of the proceedings. So, my lord, it is the authorities that become very central. And when I read the statutes, it will become clearer. 33, my lord, I just mentioned 32. Said admission of students, sorry, my lord, shall be made by an admission committee consisting of the Pro-Vice Chancellor, the principal of an intermediate college, who shall be selected by the Vice Chancellor, and such other persons as may be appointed by. Here, my lord, it's without the reference to the external bodies of the Governor General or the visitor or rector, as the case may be. Then, my lord, section 33 on PDF 15. So, my lord, there is some overlap, residuary power in the governor. There's no doubt about it. My lord. We're not saying that. But the mobilizing factors remain the court. And then 33, my lord, that is on PDF 15. All arrangements for the conduct of examinations shall be made, and all examinations shall be appointed by the academic council in such manner as prescribed by the ordinances. So, my lord, it is the entire administration moves in, apart from that residuary power that your lordship has pointed out. And then what follows from these powers, my lord, is explicated in para 50. That is the right to appoint, the right to governing body, etc., etc. And TMA Pi makes this abundantly clear. Now, my lords, statutes. Why do you want to say it? Now, my lord, the Vice Chancellor, as I've shown to your lordships, is appointed by the court. I've already done that. Now, kindly come to PDF 17. That is statute number 3. The Vice Chancellor shall take rank in the university next to the Chancellor and Pro-Chancellor, and shall be ex officio Chairman of the Executive Council and Academic Council. In the absence of the Chancellor, and Pro-Chancellor shall preside at convocations held for conferring degrees. Then there are certain emergency powers, my lord. Then, my lord, your lordships may kindly come to the Treasurer, my lord, in Statute 5. The Treasurer shall be appointed by the court on such conditions and for such period as the court may think. So the court, my lord, comes in as the appointing body and as far as the terms are concerned as well. Then, my lord, you come to statute 6 relating to the registrar. The registrar shall be a whole-time paid officer of the university appointed by the court. So all these appointments, my lord, that are crucial to the administration are in fact appointments by the court. Now, my lord, and the registrar's functions are. Now, my lord, I come to the very important aspect of statute number 7. The following of officers shall be appointed by the Executive Council on the recommendation of the Academic Council. That's the proctor and the librarian. This is an important internal part of the administration in which that overall vetoing power is not there. Then, my lord, I come to Statute 8, which is absolutely fundamental. Finally, first come, my lord, as to who are the ex officio members. Now, kindly read the ex officio members, my lord, along with 23 provisions. Because once they become members of the court, they automatically, my lord, are Muslims. So who are they, my lord? The Chancellor, Pro-Chancellor, Vice-Chancellor, for the time being shall be ex officio members. But by virtue of being ex officio members, they must necessarily be Muslim if the proviso to 23(1), my lord, is to be taken into account. Now, my lord, kindly see foundation member.
As a matter of fact, they've been always Muslims?
Sorry? Yes.
As a matter of fact, they've been always Muslims?
Yes. My lord, I'm first dealing with the de jure argument,
No, but
and we'll come to the de facto later. De facto, as has already been pointed out by Mr. Shadan Farasat, my lord, that argument has been spelled out, therefore I don't need to repeat it. Now, my lord, kindly come to the foundation members. Of the 180, my lord, 124 were foundation members. Necessarily had to be Muslim. To read it, my lord, along with 23 proviso. And this is 124 at its inception. Naturally, they continued to be less and less as we moved on. So 124, my lord. Now, my lord, the next one is life members. This is all part of the court, my lord, and that's the important part. They all have to be Muslims. Then, my lord, ordinary members shall be elected or appointed as follows: 10 persons to represent states in India. And these 10 persons also, because they are members of the court, they have to be Muslims. Then, my lord, 60 members who make a donation, as long as they are...
Just 1 second.
The important point in statute number 8 is they all have to be Muslims.
Statute 8 says that the court shall consist of the following members.
That's right.
The proviso to 23(2) says every member of the court has to be a Muslim. Therefore, that will apply to every person who is defined to be a member under Statute 8. That's
because earlier your lordship did indulge is not the right word, my lord, in some mathematics about 20, 34, etc. Actually, all of them, every single one of them will have to be a Muslim.
De jure. I mean, that's apart from Shadan's
I'm on de jure, my lord.
Yes.
De facto has been argued, and to the extent I want to refer to it, my lord, I'll refer to it. Now, my lord, therefore, the 10 persons to represent states by virtue of the proviso will have to be Muslim. Then, my lord, 60 persons elected by persons who make donations. My lord, by virtue of the proviso, they will have to be Muslim. Then, my lord, we come to 20 persons elected by the Standing Committee of the All India Mohammedan Educational Conference from amongst its own members, not less than 10 of whom shall be members who have engaged at least 5 years in teaching. They have to be, my lord. Now, 7, my lord, is very important because all members of 15 members, that's subsection, that's 7, 15 members to be elected by the academic council from amongst its own members. Who will they be, my lord? They will be Muslims. By virtue, my lord, of going into the proviso read with Statute 8. So predominantly, my lord, across the board, they have to be Muslim in that first phase. Therefore, my lord, 15 of the persons in the academic council has how many? 28. 28. Therefore, 15 of those 28 in the academic council will necessarily have to be Muslims. Then, my lord, Statute 9, the members provided for in classes 1, 2, 3, and clause 1 of class 4 shall be members of the court. Now, my lord, kindly come on PDF 21. The Executive Council shall consist of not more than 30 members. Vice Chancellor, Pro-Vice Chancellor, Principal, Intermediate College, who shall be elected by the Vice Chancellor and the Treasurer to be ex officio members. But here, my lord, subclause 3 is important. That Statute 15(3). 6 other members shall be elected by the Academic Council and 20 shall be elected by the court, of whom not less than 7 shall be residences from outside in the United Provinces. May I come to Statute 16, my lord, which is important. I've already indicated the composition, my lord, of the Academic Council will necessarily 15 of them. Then, my lord, if your lordships will come to Statute 16 in PDF 21. The Executive Council shall, subject to the control of the court and to the acts, statutes, and ordinances, administer the revenue, properties, regulate the finances, and so on. So the Executive Court will be subject to the control of the court. Then, my lord, footnote 3, want what read? Yeah, I've read that. 15(3), 6 other members shall be elected by the Academic Council, and 20, that's important, I'm sorry, you were right. And 20 shall be elected by the court. So, my lord, there are 20 there that shall be elected by the court. Then, my lord, 16 I've read under the control. Now, my lord, kindly come to the Academic Council. I've already indicated that 15 members of the Academic Council are part of the court, and therefore necessarily, my lord, those 15 in the Academic Council will have to be Muslims by virtue of the proviso. Now come, my lord, to Statute 17. The Academic Council shall consist of Vice Chairman, he is a member, my lord, of the court, librarian and proctor by the EC. Then, my lord, kindly come to PDF 22, 2 persons elected by the court. Now we add to these the 15 members, my lord, which we have indicated, my lord, who would be part and parcel, my lord, of the court and therefore members. Then, my lord, various, I don't think it's relevant directly to the control, but the departments of studies, your lordship has seen, we've already pointed it out, Sunni theology, Shia theology, and so on. Now, my lord, come to Statute 20, PDF 23. 20 is very, very important, my lord. Subject to the general control of the court, all appointments in the teaching staff shall be made by the Executive Council from a list of persons recommended as suitable, therefore, by the Committee of Appointments, consisting of Pro-Vice Chancellor, Chairman, Department of Studies. So here, once again, my lord, what we see is subject to the general control of the court. The foundation members, my lord, has already been shown to your lordships on PDF 24, 25 and 26. Well, all the way through. They're all Muslims. So, my lord, what I'm indicating to your lordships, although 51, my lord, which was said to be just to bring it up to date with the Constitution, 65 was an emergency measure, which is rectified to some extent in 72 and 81. And in 81, my lord, there is a full restoration as it was in the
Can we
1920s.
go briefly to the 1951 now, so that we can see what is the next?
Just show me.
The evolution is then complete.
My lord, I cheated a little, my lord. I'm relying on this. It was easier for me.
I
Because
noticed
marked-
that you are not on your iPad.
No, it will go further and further, my lord. I told you he's my guru. If he can do it, I can do it.
My
Give it to
cousins
me.
was in the.
Well, the solicitor had indicated a chart. Now, let's see the statute itself. Lord, I'm sorry. What's wrong with it?
Oreo tool.
It's also there in volume.
I wanted to. Take it from the chart, my lord, which the solicitor, or does your lordship want to see the statute?
Could we just quickly go through the statute, because
Yes.
it's much better, you see the statute
Yes,
as
it
it
is.
stands.
It is.
The chart is excellent, but just, since we are at it, it may take 5 minutes more.
Might as well
And
see it in its
51,
totality.
let's see what 51 does now.
Certain
I thought we
glitches.
can spend a little time, because this is really the heart, also what about administration,
Yes,
the du jure, as you said.
yes, certainly.
So let's go to the 51, what 51 does now. Apparently, the founding members
51.
were to retire after 5 years, like the Council of States, like the Rajya Sabha. So many people would retire after every year after 5 years, and they were eligible for re-election.
That indubitably, my lord, indubitably. So this is the 51 Act.
Now, 1951 is volume 4A.
Did your lordship want to see the 51 Act as well?
Yes, I think we
Yes, certainly.
just have a flavor of what
Certainly.
happened there.
My lord, what is the PDF of?
Page 4A, the volume 4A, page 19.
4A, page 19. Now, my lord. An act to further amend the Aligarh Muslim University. Act is called the Amendment Act, my lord. 30 and 31 shall come into force at once, section, and the remaining provisions of the act shall come into force on such date as these are, my lord, machinery provisions. Then, my lord,
I'm sorry, I missed out the page number, PDF page number.
Page
Page 90.
90, page volume 4A.
इसमें क्या क्या दिखाना है बता रहे हैं, but file. Then, my lord, your lordships will see section 2 of that act. No, nothing much there.
Section 5
Yeah.
needs to be looked at.
91. So, my lord,
T1.
91, section 5, which is really the section.
Classes, castes and creeds.
This is now a substitution for section 8 that I've read out to your lordships. University open to all classes, castes and creeds. The university shall be open to persons of either sex or whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever of religious belief or profession in order to entitle them to be admitted therein as a teacher or student. What was section 9 and
Education. This is curriculum 9.
your lordship reads section 5. Aziz Bhasha is right in saying that these were to bring the statute in conformity with 28, my lord, and 29 too. So that's the change that is made in section 5. Then I'll take your lordship to section 8.
29.
6 में क्या कुछ नहीं है.
Deletes 9, na?
Hmm.
Section 6 deletes 9.
If there is any provision which, there's just, you can tell us so that we'll read that as well. Yes, section 8.
What is section 9?
Section 9 was compulsory instruction, na, which was deleted.
9. That is, my lord, section 6, my lord, it deletes the compulsory education part. And this is again consistent of religious education.
Completely omitted.
Then, next one.
The word court. Section 10. Section 10.
10 is important. Section 10. For the words Lord Rector, wherever they occur, the word visitor shall be substituted. So, my lord, the visitor's power is there in every statute, my lord, whether it is a minority statute or otherwise. Then, now, my lord, section 14.
No, just read the.
In no act, Lord, of any other act of university, the visitor has power to approve, amend, etc. the statutes and ordinances.
It is there in Central University, my learned friend is wrong.
State universities talk about it.
Talking about Central University.
This is not a central university. This is not a central university. This is not central.
Lord, when I was president of the Cambridge Union Society, my lord, we followed the rules of Parliament, which was somebody gets up, I accept his intervention or I don't accept his intervention. I don't accept that intervention, my lord, for reasons stated by Mr. Sibal. Karan Thapar goes on and on. Why didn't we are the only father and son, my lord, who were presidents? Just an aside, my lord. Now, my lord.
becomes executive council.
Right.
And for the word courts.
Where I,
Right, section 10, B,
Yes.
as Mr. Sybil said.
Yes, that's
court
right.
Becomes,
executive council.
For the word court, wherever it occurs,
Executive.
the executive council. And there is in 10, my lord, in C, the visitor shall in every case give notice to the university of his intention to cause an inspection or inquiry to be made, and the university shall be entitled to appoint a representative who shall have the right to be present and be heard. Now, this brings in a very important element.
Just to clarify, in section 10, court is divided with the executive council only for the purposes of section.
That's right.
Just to.
No, that's important, only for the purpose.
so it says for the word, right, in section 13.
Only with respect to 30, not otherwise.
I accept that intervention, my lord.
Guru's intervention has to be accepted.
Now, my lord, section 11, my lord,
This happens in parliament also, Mills, because somebody gets up and the person who is speaking, Mills, says, please yield. And I have to decide whether I yield, or whether I yield or not. Or I don't allow.
perhaps your lordship can be a little more lax, my lord, in court.
If you don't yield, Mills, you cannot enter.
Oh.
But nowadays, shouting goes on, so that.
Now, my lord, section 14.
Section 14 is the visiting board, judiciary.
Now, my lord, there was a visiting board in section 14. I'm instructed that board never met. And therefore, my lord, that provision for a visiting board, which was an extra, has been deleted by section 11. Then, my lord, certain substitutions, because the governor, my lord, then becomes the chief rector.
Chief rector. governor.
And that is in section 12. So these are machinery provisions to bring things in line with the constitution.
It says successors of the first vice chancellor to be appointed in accordance with the statutes.
11. और क्या?
In section 17, sir, proviso is deleted, no?
Important part, my lord. 17, the proviso was deleted in section 23. And Basa says that in effect in this statute, there was no substantial change that was made. Those
But Mr. Dr. Dhawan, would the deletion of the proviso to section, deletion of the proviso to section 23 not be a very important change? Because until then, no person could be a member of the court in law unless they were Muslims.
right.
Now, post 1951, the requirement of having a Muslim as a member of the court is completely done away with.
Except, my lord, that I've already shown to your lordships that many of the members of the court had, by virtue of phase 1, my lord, necessarily had to be Muslim. This is removed in phase 2.
That's in phase 2 that is removed.
That's right.
Changes have happened on the ground.
Now, my lord,
This is because if, we proceed on the basis that the court was a supreme executive authority, and post 1951, therefore, the membership of the supreme executive authority is no longer defined by religion. You could be a member of any religion to be a member of the court.
that, my lord, is a consequential amendment from the constitution.
No, not necessarily. You may still have, even today, You may have a managing committee of, say, an education institution where the entirety of the managing committee consists of Parsi Zoroastrians, Christians,
Yes.
Muslims, or whatever.
So this is significant, my lord.
To
I'm
an
not
extent,
saying
that
it's.
is significant. We'll have to.
And we were right, my lord. Your lordship was right in going into the statute itself. No? Section 19. Is the power to make statutes which will provide for the constitution, power and duties of the authorities of the university, which I've indicated already, my lord, earlier. Election and continuance in office of members of the said authorities, that's a continuation clause, including the continuation in office of the first members and the filling of vacancies of members and all other matters related to those authorities for which it may be necessary or desirable to provide. The rest, my lord, are not important, except section 20.
Where 20 subsection 6 now says, any amendment to a statute or a new statute requires a previous approval of the visitors.
Yes. So this happens, it is inherent, my lord, in the nature of the visitor's powers. That's the powers of inspection and otherwise. Now, my lord, we come to 20, section 20. Subsection 2, my lord. The court may from time to time make new or additional statutes or may amend the repeal of the statutes in a manner indicated herein. So, my lord, the court comes back and may from time to time make new and additional statutes or may amend the statutes, and the procedure is that the Executive Council will propose. And then finally, my lord, in subsection 4, the court may approve any such draft as referred to in subsection 3 and pass the statute or reject it. So the court's power, my lord, to that extent are there, my lord, in substituting section 28, and the court's power, my lord, are certainly there as far as the statutes are concerned. I don't think there's anything more. Let me take your lordship to the 65 Act, if I may, my lord.
Subsection 4, there's
Just
an
one-
appellate power given to the central government. On the statutes, if there's a difference between the.
Yes. So, my lord, all that happens is in accordance with the Constitution. That's one part, my lord. And the second part, the court's powers are made subject to, as the rector's powers or the visitor's powers are made subject to the court. And then, my lord, court eventually has to approve that, my lord. I've already pointed that out.
21(7), the visitor can suspend the operation of any, so 21(6) and 7 may suspend any ordinance.
No, can they do it? No. Power of repeal.
My lord, this is a backup power in the visitor, and with many variations, my lord. The proviso, my lord, to subsection 4 is provided that if the ordinance is not approved by the court at such meeting, it shall cease to have effect. That is section 4.
25A, the auditors are no longer now appointed by the visiting board, but by the Comptroller and Auditor General of India.
Yes.
See section 25.
Not here.
Yes, 15 only.
Now, section 24, my lord. I'm making a distinction, my lord, between the internal administration, in whose hands it is, and the external, my lord, supervisory or other powers, as the case may be. So, my lord, if your lordships were to look at, your lordship was on 25, the auditors. The Controller General comes in, my lord, which is a salutary provision.
In this 1965 Act, somehow missed that actually. Which provision?
In the 65 Act, my lord, what happens is this function becomes advisory.
But how, where is the expression visitor defined in the 65 Act? Actually, I was just checking that out.
51 Act, my lord? Or-
No, we are now on the, we are on the 51 Act, sorry.
Yeah.
How is the expression visitor defined? Somehow the other, I just seem to have missed that actually. Well, I was looking,
Section 13 minutes.
section 13. is it? Section 10.
Yes. The Lord Rector, wherever they refer, the word visitor shall be substituted.
But how, no, but who is the visitor?
The Governor General.
Where do we get that?
The Governor is substituted, my lord.
Even Section 13, Governor General becomes the President of India.
Right, section 10 says visitor is substituted for Lord Rector for the purpose of section 13.
Yes.
Then section 12, Governor of UP becomes the Chief Rector. But where do we have in this 1951 Act, who is the visitor? There must be some provision defining us, defining, who is a visitor.
Who's the visitor? Just give me a
I
moment.
was checking whether, there is an amendment to the,
Originally, it was the Governor General, but then as soon as we became independent, but the President.
Governor General was the Lord Rector.
That's right.
Though the Act used the expression both Lord Rector and Governor General in Council separately.
Because
Right. And then comes
Lord
in,
Rector was changed, but the Governor General became the President. The Governor General, the President of India took over the function of the Governor General.
right, under the Constitution.
Yeah.
That must have been
That's
under,
what-
under Article 370 or something.
Yes, exactly.
But,
they must have-
372, sorry. But what about the visitor? And who is to be the visitor in this Act? Unless there's a casus omissus there.
Is there any provision?
You only replace the word Lord Rector in section 13.
Who's the visitor?
That's all that it is.
No, the word visitor would have been still defined somewhere.
Somewhere.
It cannot be. This cannot be.
Find the original section 13 minutes will make it clear. Volume 3,
Yeah, we have that opened actually.
original section 13. Have a look at that.
Because, my lord, the Lord Rector under section 10, the word visitor shall be substituted.
Who's the visitor?
Therefore, the two, it's a matter of substitution.
Okay, so what happened was the president became became the Governor General, and because of the Lord Rector got substituted
Yes,
by
sir.
visitor there, that's all.
And this is all to bring things in conformity with the Constitution.
Oh, right, because actually it was, right, the precedent, because we got that now at page 45 of volume 3G. That's where, because that's the 1920 Act as amended. And there's a footnote that, that section 13 of the erstwhile Act was amended by section 10 of the 1951 Act so that the President of India became the visitor.
And that would be, my lord,
If you're not lordship looks at page
Of?
of this, PG, give some clarity. Governor General shall be the Lord Rector of the University. And
That's.
the Governor General became the President, and the Lord Rector became the Visitor. That's what. Hope that's clear.
That is in 10, my lord. That rector became visitor.
To define the
Yeah.
65 Act.
Visitor.
Concept, PDF. And
Now the President is the Visitor as the Act is on today, as on today. That's at page 45 of the same volume. Now the President shall be the Visitor of the University. That's 13.
General got substituted for President, T1 Act,
Correct.
and when the, with the Constitution itself, and 51 Act says Lord Rector will be now read as Visitor.
That's correct.
So the circle is complete.
Then now the Visitor is the President. That's how it is.
Because we substituted Lord Rector with Visitor, the President becomes Victor. Well, the visitor of the.
This is PDF, which
Now, my lord, the 65 Act, your lordship will find in the same volume at 99. The important section here, my lord, is section 2, my lord, which changed section 23.
Where do we get the 65 Act now?
My lord, PDF 99
Of this, of volume?
4A, my lord, same volume.
Yes.
Voice transfer will be omitted. Well, I'm taking your lordships to section 2 of that 23 is substituted. And the important, my lord, section is, my lord, B. For subsections 2 and 3, the functions of the court shall be to advise the visitor in respect of any matter which may be referred to the court for advice, to advise any other authority in respect of any matter which may be referred to the court for advice, to perform such other functions, such other duties, and exercise such powers as may be assigned to the visitor. So, my lord, it becomes an advisory body. That is the big change that is made. Our submission, my lord, on this would be, once you have decided the question of established by a statute, then everything else, my lord. But had that not been decided, that part of the statute part, these should have been struck down, my lord. Because they're quite clearly invasive. But of course, this is the precursor to this was,
Mr. Dhawan, then you are accepting that post these amendments, there was a change in administration
yes,
and the minority role as far as administration is concerned by these amendments was diluted. I'm using a,
I'm still on de jure. We come to different.
that's something separate. De jure, it was certainly diluted, if not withdrawn.
What I'm saying,
When
what
you
I'm
argue
saying,
and say it should be struck down, you're accepting that.
my lord, what I'm saying is, my lord, had the Ajiz Bhasha, the ratio of Ajiz Bhasha is statutory intervention removes the, had that not been decided and had they gone into these questions, these invasive provisions would have been struck down. That's what I'm saying. And of course, there is a restoration, my lord, where I'll just come to.
But Dr. Dhawan, now we are operating today 65 amendment has been made 35 and now 24, that is 59, 60 years ago. Do we strike down that amendment after the lapse of 60 years?
No, no, I'm saying you could not have struck it down because of the alternative ratio.
Basha said it was not established
if-
by a Muslim minority
Because
because
of
it
the
was
statute.
established by statute.
Statutory intervention.
Once establishment goes away for
Yeah.
Basha, it says it's not an MEI institution.
No, that's right, Manoj.
Right.
I'm only saying,
So what you are saying is
had the,
Basha
if your lordship were to hold
it is
that the
established.
statutory intervention part of Bhasha is incorrect, then some of these provisions are invasive.
So which means we'll have to strike them down today
No, no,
to
no.
uphold their
not-
argument.
I'm not merely making
Dr. Dhawan,
the,
I'll tell you why. Unless we strike down those provisions now, these provisions still operate on the statute book. Of course they do.
Yes, of course. Even only changes the preamble as.
Exactly, by
Amended in 81 and the old position is restored, please.
one second. Bol do. I accept your intervention.
What's the, all the.
Just what to.
My lord, I'm not asking your lordship to strike it down now, my lord. I'm just saying
We recorded
that
that.
this is a logical consequence.
We record that submission on behalf. And when we were arguing for the first, that you're not asking for striking down of 1951
Right.
and 65.
I'm saying it would have been an alternative had the ratio been confined to establish.
No, but even if we say that in your, let's assume everything in your favor, that we hold that Basha is wrongly
On
decided.
question of establishment.
Yes,
Even so, on the question of establishment,
yes.
right? Even so, the amendments which are made in 65, they don't get obliterated from the statute book merely because we say that Basha is wrong. Because that's an independent exercise of Parliament's legislative power.
Yeah, fair enough.
So we will have to say therefore, now look at the problem in our part. We will have to then say that because Basha is wrongly decided on establishment, there was a challenge to the constitutional validity of the 1951 and 1965 amendment before
It wasn't
Basha,
decided.
which was not decided. Now we have to decide it today in the absence of really any challenge before us. If we don't decide it, as we cannot after 65 years, that means those amendments of 1951 and 65 continue to hold the field today.
So that is what.
My lord, the point is, my lord, I'm sorry.
That even if we accept that in 1981,
So 81 they go.
some restoration, partial or full.
Not some, my lord, a radical.
Okay,
restoration.
partial or full, I say.
Yes,
That's something separate. But from 1965 or from 1965 to 81, it was not a minority institution.
my lord, I've said that. There are problems in that particular phase. I've indicated that. But my lord,
Can that be then restored?
my lord, for that period, of course, your lordship will look at the de facto argument, my lord, but at this point in time, the reason why I put it in phases, my lord, was precisely because apart from this glitch that existed in 65, I've mentioned that the restoration then comes in 81, which I'll just show to you.
So your argument is because of the restoration, it came back.
That's right.
De jure argument.
Banatwala inquiry in 72 itself. will show-
And my lord, your lordship will bear one thing in mind.
And significantly, the 81 amendment, when in Parliament, this question is specifically raised, that you have merely done a facial amendment by saying established and deleting established and changing the definition of university. But you have not done anything to change the basis in the sense that you have not amended,
My lord, I'll
you have
take
not
your
changed
lordship
the
to 81.
administrative provisions.
My lord,
That's what Banatwala said,
three
Brother Dipankar
three
said.
provisions, my lord, are facial in nature. That's the preamble, my lord, 2L and 52C. Assume, my lord, that they're not there. The rest of the 81 Act, my lord, also makes restorative provisions, which I'll show to your lordship.
So 65 law, the Act of 65 continues to hold the field between 1965 and 1981.
My lord,
71.
72 Parliament brings another amendment.
Now let's see the 72 amendment. We have seen now the 65 Act.
we've shown the 65 Act.
65, anything apart from this that we have to see?
72, I've already indicated to your lordships, my lord.
65, everything.
My lord, just kindly come to PDF 107.
That's the 72 amendment.
Matika.
Effect minutes.
I think our arguments about the court.
This is temp-
Page 102.
20 of the interesting one. Why? 502.
By the 1965 Act, look at also the amendment to Statute 8 at page 102 of volume 4A.
Correct. Kindly look at that. That's not in the chart of the Solicitor General.
No, that's right. Let's see that. Statute 8.
Section that 8. The court shall consist of the following members: the Chancellor, the Pro-Chancellor, members of the Executive Council, key person.
Which page are you?
Page 102. This is very important. Huh?
It's very important. Worship had that?
Yes.
It says the court shall consist of the following members: Chancellor, ex officio, Pro-Chancellor, ex officio, members of the Executive Council, ex officio, 3 persons being heads of Department of Studies or principals of college of the university nominated by the visitor. Now, as your lordship knows, the visitor is the president. 2 persons being professors from departments of studies or colleges of the university nominated by the visitor. 2 persons from among teachers of the university other than the professors nominated by the visitor. 3 representatives of parliament, 2 of them nominated by the Speaker of the House of the people from among the members thereof, and one to be nominated by the chairman of the council of states from among the members thereof, and 30 persons nominated by the visitor. So the whole basis was changed. Now kindly come, there's another element your lordships must look at. Yes, it's taken over. Now kindly look at Mullahs, they changed the executive council. Kindly look at page 103.
That's for statute 15.
Yeah. Now see 103 now. Statute 15, the executive council shall consist of the following: the vice chancellor,
Who's nominated?
7 persons nominated by the visitor, and 1 person nominated by the chief rector at his discretion. And all the members of the executive council other than ex officio members shall hold office for a term of 3 years. So the whole institution was taken over. Now Pasha doesn't decide that, because Pasha says, we're not established, so that's the end of the matter. That's what happened. But I'll address your lordships differently on this. This also is not provided by the solicitor in his lecture.
Then says, every person who was a member of the court shall, on the 20th of May 1965, cease to hold office.
Yes. Take one over completely.
That is at page 105.
This situation, 65.
We have completed the 1965 Act.
The position is partly restored in 72 and fully in 81. That's what I'm sorry.
Let's see the 72 Act now.
My lord, 107.
Volume 4C, right? 4A, page 70. Page 107. Chalo dekhte hain.
My lord, I want to refer to one part of the SOR, because Mr. Chagla, my lord, had mentioned that 65 was a temporary measure because there was a lot of agitation, etc. This is reinforced in the SOR, in the prefatory note, my lord, in 72. I'm on page 107. 4A, you said, how many times do you have to say it? May I read that prefatory note, my lord? Because that is a declaration of Parliament on what 65 in fact did and in what context it did. It passed the 65 Act. May I just read it, my lord?
Yes.
Now, my lord. Prefatory note, my lord, statement of objects and reasons. as a result of disturbances that took place in Aligarh Muslim University, the president promulgated, just change it. What was I reading? Aligarh Muslim University Ordinance 65, and on 20th of May 65, the amendment came into play. The ordinance was later replaced by the Act of 65. Both the ordinances and the Amendment Act were temporary provisions to tide over the difficult situation which was prevalent in the university at that time, and the intention was to bring before Parliament in due course a comprehensive long-term legislation. And then it says why it could not be introduced. So this is a statement by Parliament itself.
Dr. Dhawan is very important, that the Justice Gajendra Gadkar committee was appointed.
That's right.
By the UGC. Everything was deferred until the report of the Gajendra Gadkar committee was appointed. Now see para 2 and para 5, they say that the recommendations of the Gajendra Gadkar committee are received, and the Gajendra Gadkar committee has proposed that all central universities should be brought at par. And in pursuance to which this is amended. So then this idea is to make this at par with central universities appears. See para 5, the report of the Gajendra Gadkar committee on governance of universities was received by government in July 71. Recommendations of the committee were accepted both by UGC and government in principle. It was also decided to amend the acts of central universities in the light of the recommendations made by the committee. Based on the recommendations of the committee and taking into account all other cells, in fact, as government decided to introduce this comprehensive legislation for Aligarh Muslim University.
Yes, that's right.
Preface also the
And
last.
para 2 as well.
In prefacing the last line.
It was government that the report of the committee should be awaited before introducing long-term legislation for Banaras Hindu University as well as Aligarh Muslim University. And the second sentence, the intent all along was that the legislation for BHU and AMU should be broadly on similar lines.
But what happened, my lord, is Basha had come by that time.
Really speaking, they say in paragraph 3 that they were anxious to have a democratic setup because there was a Golden Jubilee celebrations in December 1970.
Para 2 on par.
And therefore, the Amendment Act of 1970 was introduced. But the bill got defeated.
65 has an intention to bring on par. I'm not saying it didn't. But at the same time, 72, at the same time, my lord, the more comprehensive changes were made in the 81 Act. Because the report hadn't come, all those things were not done. And then I'll take your lordship. Now, my lord, let me just read from the SOR, my lord, the main features of the bill.
Yes.
The main features of the bill are, this is in 108, my lord. The university is being given additional powers. Important amongst them are provision of instruction through corresponding courses, establishment of special centers, specialized laboratories, and such other units for research and education as are necessary, and for further the objects of the university within a radius of 25 kilometers of the university, and appointment of persons working in other universities, institutions, or organizations as teachers. In view of the persistent demand for preserving the residential character of the university, the provision in the Act of the university for affiliation is being deleted. So earlier, my lord, the affiliation to Allahabad, and now is being deleted. Then, my lord, it goes on to say, sub-Roman 4, the constitution and functions of the court, executive council, and other authorities of the university are being revised in the light of the recommendations made by the Gajendra Gadkar committee. The court will thereafter be a deliberative body and will not be saddled with the authority to overrule the decisions of the executive council and other bodies. And then, my lord, Further down, the court will consist of 104 members at this point in time.
Yes.
Just kindly come to 110. And clause 9 now.
Amendment 4.
Amendment 7.
Section 4 of the Amendment Act.
I don't see it here.
Section
Just mark the bloody thing here.
Section 4, Your Honor. Section 4, 7, clause
7, yeah. My Lord, section 4, sub-Roman 7, my Lord. For clause 9, the following clauses shall be substituted, namely to institute and maintain within a radius of 25 kilometers of the university mosque, hills, halls and residences, and to recognize places of residences for the students of the university within the said limits, and to withdraw such recognition according to any such place of residence. And then, my Lord, clause 9, 9A, to establish within a radius of 25 kilometers of the university mosque such special centers, specialized laboratories for research and instruction in the opinion of the university necessary for furthering its objects. So those provisions, my Lord, of 25 kilometers, which are part of the functions, my Lord, of the university and show continuity, my Lord, they will remain. Of the mosque, yeah. My Lord, this is an interim measure which was substantially changed in 81. May I take your lordships to the 81 Act, my Lord?
Before that, now what another very important thing it does is that it says that the chancellor will be now appointed by the visitor according to the statutes. The pro-chancellor and the vice-chancellor will be appointed by the visitor by statute, and the statutes are now provided in the first schedule under section 28.
Yes.
See, because section 28 says, section 28 is amended, section 24 of this act, page 115, on and from the commencement of the Amendment Act of 1972, the statutes as set out in the schedule shall be the statutes of the university. Now let's go to the schedule and see what the schedule does.
Schedule. No, we'll come to the 81 Act. 119.
119. Now see what this does. Look at the amended statutes, page 119.
Yes, sir.
Now the modalities for the appointment of the chancellor is that the chancellor shall be appointed by the visitor from a panel of not less than 3 persons recommended by the executive council.
Yes, sir.
So really the appointment of the head is now vested in the visitor completely.
It is, my Lord. That part has not been changed. We will only see the changes now, my Lord, in the 81 Act. Because at that stage, my Lord, Bhasha treated it as a non-minority institution. And these were consequential changes following Bhasha.
Now, statute 14 is substituted at page 125. So the court. Now, see who is in the court. Court now becomes vice-chancellor, ex-vice-chancellors, pro-vice-chancellor, deans of faculties, students' council, students' welfare, librarian, representatives, principals of each of the following colleges, namely Women's College, Tibia College, and Polytechnic by rotation, heads of department, 5 professors, representatives of students, representatives of ex-students, representatives of parliament, members of the learned professions, nominated members, remaining members. So would it be correct to say that, by the 1972 Act and the statutes which are substituted, the Muslim character of the institution as it existed in 1951 and following the 1965 Act, because 72 Act has never been in challenge.
There's never been, that's true.
And this now becomes completely a secular management, isn't it? See what happens to the Executive Council, for instance.
My lord, we have to come to 81, my lord, to see those changes because they are the definitive ones.
So we'll
More democratic.
because we will now have to see finally what did 81 do, what was restored under 81 and what was not restored under.
Let me come to that.
Yes.
148. 140. वो इसमें वो कहाँ है SOR ठीक है May I just read, my lord? My lord, the prefatory note, my lord, in 148 says, the SOR, India is a multi-religious country and its strength lies in the fact that all communities living in the country are free to establish educational and other institutions of their choice. The government have introduced in Parliament an amendment bill to remove the doubts in the mind of the Muslim community regards the character of the Muslim university, but the amendment of the Muslim University Act would be meaningless and would become redundant if the statutes are not amended to satisfy the sentiments of the Muslim community. Therefore, my lord, it is therefore necessary to introduce a bill in the Parliament to achieve these objects. That is the purpose, my lord, in the SOR. Now, my lord, subsection 2, my lord, says in the Aligarh Muslim University Act 1920, herein referred to as the Principal Act in the long title and in the preamble, the words establish and shall be omitted. This was struck down, my lord, by the Allahabad High Court. Then, my lord, if your lordships will come to section 3, that is L, my lord. University means the educational institution of their choice established by the Muslims of India, which originated as the Mohammedan Anglo-Oriental College, Aligarh, and which was subsequently incorporated as the Aligarh Muslim University. And this was struck down as well. Then, my lord, kindly see section 4, which amends 5. 5.1, my lord, to promote specially the educational and cultural advancement of the Muslims of India. Your lordship has seen that? That was also struck down.
What was struck down was that.
Now, my lord, I want to take your lordships to the other provisions that are important. Section 12, my lord, was not challenged. The court shall consist of the Chancellor, Pro-Chancellor, Vice-Chancellor, and Pro-Vice-Chancellor, if any, for the time being, and such persons as may be specified in the statutes. This is also a restoration, my lord, of the earlier provisions. Then, my lords, I need to, subsection 2. The court shall be the supreme governing body of the university and shall exercise all the powers of the university not otherwise provided by the Act, statutes, ordinances, and regulations, and it shall have the power to review the acts of the executive and academic councils, save where such councils have acted in accordance with the provisions. Then, my lord, the powers are given in subsection 3. I think I've got it here. Subject to the provisions of this Act, the court shall exercise the following powers. These are the provisions, my lord, that empower the court once again to make statutes and to amend or repeal the same, to consider ordinances, to consider and pass resolutions of the annual report, annual accounts, and the financial estimates, to elect such persons to serve on the authorities of the university, and to appoint such officers as may be prescribed by the Act. And then, my lord, E, to exercise such powers and perform such duties as may be confirmed or imposed by it by the Act or the statutes. So, my lord, many of the provisions that were there in the original Act, my lord, have come back. And I'm not dealing, my lord, with the... And none of these, my lord, I had argued the case, my lord, before the Allahabad High Court. None of them were challenged.
Just section 7.
I want my learned friend. It's important, my lord, section 7, my lord. In section 17 of the Principal Act, the following subsection will be substituted. The Chancellor of the University shall be elected by the court in such manner and for such terms as may be prescribed. So here the Chancellor is now elected by the court. As your lordships will see, the Pro-Chancellor will also be elected. The Pro-Chancellor shall be elected by the court in such manner, same thing. Then, my lord, in the Principal Act, the Treasurer, my lord, your lordships will see what is introduced here in 20 capital A. The Honorary Treasurer shall be elected by the court in such manner. It's then, my lord, if your lordships will come to 12. No, 20 Finance Commission, etc. 12. Substitution of a new section for section 23. This is section 12. None of this is challenged, my lord. The only challenges were made with the 3 provisions that were struck down. The court shall consist of the Chancellor, Pro-Chancellor, Vice-Chancellor, or the Pro-Vice-Chancellor, if any for the time being, and such other persons as may be specified in the statutes. Then, my lord, subsection 2, the court shall be the supreme governing body of the university and shall exercise the powers of the university not otherwise provided by the Act, etc. Then, my lord, the duties are mentioned in subsection 3. Subject to the provisions of this Act, the court shall exercise the following powers and perform the following duties. This is the court again to make statutes, to amend or repeal the same, to consider ordinances, to consider and pass resolutions on the annual report, to elect such persons to serve on the authorities as may be prescribed. Anything else here? We go to the statutes. 16, my lord. There's another substitution. On the commencement of the Aligarh Muslim University Amendment Act, the statutes in force immediately before such commencement as amended by the Act shall be statutes of the university. And then, my lord, after the commencement of the AMU Act 1981, the court may, notwithstanding anything contained in subsection 1, make new or additional statutes or may amend or repeal the statutes referred to in subsection 1 in the manner provided. Now, my lord, come to section 3, subsection 3. The Executive Council may propose to the court the draft of any statute for its consideration, and such draft shall be considered by the court at its next meeting, provided the Executive Council shall not propose the draft of any statute or the amendment affecting the status, powers, or constitution of any authority, unless until such authority has been given an opportunity to express those are natural justice provisions. Now, my lords, page 152, section 35, my lord. 21 seconds. Is not important. 21. Throughout the statutes, head of department, wherever they occur, will be the chairman of the department, shall be substituted, and such consequential amendments made in the rules of grammar that may require to be made. Then the chancellor shall be elected by the court by a simple majority. The chancellor, that's 3 years, we're not concerned with that, my lord. Pro-chancellor is also, my lord, elected by a simple majority.
The proviso removing the Muslim character, my lords, that is not restored. That's not restored.
May I complete? I'm racing against time. You didn't have that disadvantage. What do you want to write?
The Vice Chancellor, the appointment of the Vice Chancellor also.
Then, my lord, in statute number 2,
By the West.
in one PDF 153, the Vice Chancellor shall be appointed by the visitor from a panel of 3 persons recommended by the court, from a panel of 5 persons recommended by the Executive Council, provided that if the visitor does not approve, he may call for fresh recommendations. So that is a process, my lord, that is important.
Then the whole.
Earlier it was visitor, now it's from the court to the visitor. My lord. Now, my lord, kindly come to the composition of the court in section 14, which had been deleted earlier. Chancellor, Pro-Chancellor, Vice-Chancellor, Pro-Vice-Chancellor, Honorary Treasurer, Treasurer, all ex-Vice-Chancellors, all Deans of faculties, Deans of Student Welfare, Librarian, Registrar, then 20 Chairmen of Departments. These are democratic, my lord, changes that take place to represent students. And then, my lord, your lordships will see on page 154, the representatives of the All India Muslim Education Conference, 5 representatives, representatives of Parliament, representatives, my lord, of Muslim culture and learning.
25 representative ex-students to be elected by
Right.
the Old Board Association. That's 20.
Then, my lord, kindly come to 25. Where are we? 15 persons representing Muslim culture and learning to be elected by the court, of whom 10 shall be persons residing outside the state of Uttar Pradesh. Next, my lord, that is 26, sub-Roman 26, 6 persons representing Muslim colleges of Oriental learning in India to be elected by the court. Then, my lord, chairman of Waqf boards, my lord, and to be elected by the court once again. 2 persons representing Urdu language and literature to be elected by the court. Then, my lord, 29, sub-Roman, 5 persons of Muslim and cultural societies situated outside the state of Uttar Pradesh to be elected by the court.
Muslim character.
Can we, my lord, argue that the Muslim character is not mentioned here?
It has been thrown out. That's what he said.
And the argument, my lord, on the other side was that the Muslims have been thrown out.
But he's challenged these provisions.
No challenge. Therefore, my lord, the 3 that were struck down are separate. Now we are looking at the administration, and which have not.
Look at is that in the court, look at the ex officio members. there is no requirement under the statute that they have to be professing the Muslim religion. So from clause 1 to clause 14 is agnostic to religion.
That's right. That's right.
Then likewise, actually from clause 1 to clause 20. 21, you get 10 representatives of donors who have donated at least a sum of 10,000 rupees. Then again, 10 persons representing learned professions to be elected by the court. 28 is certainly representatives of the All India Muslim Conference, 5. Then
Before
10
that,
members
Urdu
of
Malone.
Parliament, 10 members of Parliament. Again, there's no requirement of religion. So if you look at 23, 25, 26, 27, 28 and 29,
Yes.
these are the real Muslim representatives in
That-
the court.
My lord, there had to be a democratization. I know of no university, and I've taught in many, my lord. You have to bring the students in, you have to bring the eminent professors in. There is no other way to do it.
But can we say that now, as a matter of these amendments, de jure, that control is vested in the Muslim community by the court? Or is it that they also have a representation in the court? Would it not be more appropriate to say that now they've got a representation in the court, but they are not controlling the court, or there is no legal requirement of the proviso to section 23 that only a Muslim can be a member of the court? Because that which was deleted, the 23(2)
That's
proviso, that has never come back thereafter.
That is true, my lord. I'm not doubting that. But, my lord, the operative part in the judgment says in whom the minority have confidence.
Overwhelming majority can be
My lord, we're not,
What is the total strength of the court? In number broadly, it will vary. But it's all ex-vice chancellors. It depends on how many ex-vice chancellors are still.
all Muslims.
No, I'm not done that. What is the total number in the court?
About 180.
No, not ex-vice chancellors. Just the total number in the court.
180.
180.
And when you say vice,
out of that
vice
180,
chancellors,
out of
you
that
have to go
180,
into the de facto.
how many are drawn from clauses 23, 25, 26, 27, 28 and 29? We'll actually get it here.
About 40.
It will be
But
5.
we need, but my lord, when we say ex vice chancellors, we need to add to that number.
32, 37,
40.
37.
So that makes it 65. There are 25 old boys.
There are 4 or 5, 4 more.
Distinction between who has to be necessarily a Muslim.
They have to be.
But even 28 part of
Part of the court.
need not be Muslim.
From other religion
Because there are a lot of
The constitutional issue is not a numerical issue, but I'll argue that. Nothing to do with the issue. We're going into numericals, which has nothing to do in the context of what is a minority institution. I come to that, but let my understand finish.
So my lord, we've more or less done with this.
Done with the statute.
Now, my lord, can I take your lordships to my written submission? Just a small. Page 25, my lord, of my written submission. Volume 1F.
Whether your lordship would like to see now, my lords, or later on, my lord? Relevant portion of that committee report. We can show it later on.
No, you might as well tender it now because, then they can also look at it at lunch if there's something of relevance in that. Because you will not get any opportunity now after they've responded.
Only the relevant pages, which you've taken out, and otherwise the whole office will be.
There are so many reports in our favor.
So this 7Judges Act which talked about that report.
There's a Charity Committee's report in 1961, which is entirely in our favor. Minority Commission report is in our favor.
Since you all were referring.
Again, the court is in our favor.
All that, but ultimately, it is a constitutional issue. It's not a numerical issue.
No, the idea was to make it, to treat it as a central university.
Let me just in a minute tell your lordships what the constitution permit.
What is this?
Did I establish this university once? If I establish, I have the right to administer. I have the right to establish and the right to administer. The test is not whether I'm administering or not.
It says that
We're going into something which is not relevant for the constitution at all.
What has been handed over?
And this has been held by 11 judges.
My Lord, I don't want to get into the question of the committees, my Lord, because by and large they are in our favor. Just to take out a paragraph or two will not make a difference, my Lord. If my learned friend, my Lord, wants to do the sur rejoinder now, the answer would be very different. I don't think so, my Lord, that we go into the committees.
Now, what is the next limb, Mr. Dr.
My Lord, I am just going to one or two provisions. My Lord, page 26,
Of volume?
1F. Here, my Lord, I won't, I go to 7.3, the de facto argument. Because the de facto argument becomes important. If, my Lord, the numbers that had been appointed were de facto Muslims, then we don't, my Lord, at that stage, in any way, my Lord, we're not in any way, I'm sorry.
Yes.
Lord, I'll leave it there, my Lord. Lord, I just want to read, I'm sorry. The committee में कहाँ पहुँच गए हैं? It's an argument.
Acceptable, but just do you want?
कितना पढ़ेंगे यार ये?
University. From 20 it is centralized.
which is worrying us, we may tell you now, so you have a little time over lunch, is that the 1981 amendment does not restore the position as it stood prior to 1951. In other words, the 81 amendment does a half-hearted job. I can understand if the 81 amendment had said, okay, we are going back to the original 1920 statute, confer complete minority character on this. It says, okay, established we are changing, university we are changing the definition. So it was really they were placating that sentiment. But when it actually came to the brass tacks, they didn't go back to the position prior to 1950.
Well, in part.
And what it did was, it brought a Muslim voice into AMU's administration, as we see it, in the court, for instance. They brought a Muslim voice into the institution.
That's correct.
But it still stopped short. Even Parliament, which it had power to do, it still stopped short of taking us back to the 1920 Act or the pre-1951.
Take, for example, the foundation members.
Some of the other, they waddle.
Obviously,
and they said, okay, we'll do a little bit of, we'll make a few concessions, but they never took us back to the pre-1951 Act. That's something
to
which
some extent it couldn't have gone back. There were two elements, my lord. Firstly, the democratic elements of students, etc., were brought in. That is consistent with the fact that some democratic elements had to be brought in. We get a voice, my lord. Now, suppose, my lord, these were non-Muslims all across the map. They might be subject to challenge on the de facto argument.
All right, we'll come back after lunch.
I'll only take 5 minutes more, my lord.
Certainly.
And then I'll hand over to Mr.
Certainly. Thank you. Thank you, Dr.